Good morning, Your Honour. I'm Tristan Lacey, counsel appearing on behalf of the applicant, Mr. Smith. The defence is here seeking a pretrial ruling pursuant to Section 590AA, subsection 2E of the Criminal Code Commonwealth to have certain Crown evidence excluded from trial. In this pretrial ruling, I'll make 4 submissions in the following order. Firstly, that all evidentiary issues be governed by the Queensland Evidence Act. Secondly, that all evidence obtained during Senior Constable Stone's visit to Mr. Smith's property be excluded from trial. Third, that Mr. Tom Tyler be dealt with as a child witness at trial. And fourth, that Mr. Peter Parker's oral evidence be ruled inadmissible. My first submission has its grounds resting in the fact that the Crown is alleging my client contravenes Section 148.1, subsection 2 of the Criminal Code Commonwealth, and the matter is being heard in the Brisbane District Court. As a result, Section 79 of the Judiciary Act states that all evidentiary issues must be governed by the law of the state. As a result, this is the Queensland Evidence Act in this case. My second submission is that all evidence, including oral evidence and real evidence in form of the signs, be excluded from trial. Oral evidence of Mr. Smith shouting to Constable Stone, "It was only a joke. I only took them as a joke," should be ruled inadmissible due to it lacking any significant probative value. Your Honour, I ask, what is Mr. Smith referring to when he says, "It is only a joke, it is only a joke"? He could be referring to a large number of things that Mr. Constable Stone might be there at the property for that day. As a result, the facts are similar to the cases Christie and Hasler, which state that inherently ambiguous statements such as these can be given undue influence in the eye of a layperson, and as a result should be excluded from trial and ruled inadmissible. The second oral evidence that should be excluded is my client's silence following Constable Stone stating, "You're up to your old tricks again." Your Honour, this has the likely result of a layperson believing that my client has a propensity for pretending to be a public Commonwealth official. Your Honour, my client has never been convicted of any crime, and therefore the statement holds no truth. This oral testimony is likely to lead to the jury believing that my client has done this before. Applying the test in Fanning v. the Queen, this evidence must be excluded unless the probative value outweighs any prejudicial construction. As the statement is completely untrue, the probative value cannot outweigh the likely prejudicial construction and therefore must be ruled inadmissible and excluded from the trial. The applicant respectfully submits that the signs obtained during Constable Stone's entrance be excluded from trial due to them breaching public policy discretions, and we submit that the court uses its powers under Section 130 of the Queensland Evidence Act to exclude the evidence from trial. I will now go through the 5 factors required to establish this ground from Bunnings and Cross. Number 1, Your Honour, it is imperative that those entrusted with enforcing the law also adhere to it too. Constable Stone has violated this by entering into Mr. Smith's residence at the unusual hour of 4 a.m. in the morning without consent or without a warrant pursuant to Section 150 and 161 of the Queensland Evidence Act. As a result, this reckless disregard means the evidence should be excluded from trial. Secondly, there is no evidence to suggest the emergent removal of the signs to be used as evidence, as there is nothing on the facts to suggest to Constable Stone that the signs were likely to be destroyed or removed from the residence. Thirdly, Constable Stone may have easily applied for a post-search warrant, which may have been granted pursuant to Section 161 of the PPR. The lack of candour shown by Constable Stone in neither application for a pre- or a post-search warrant shows complete disregard for judicial procedures and basic police requirements in which the signs were taken. Fourth, granted the charges are not minor, the evidence was obtained unlawfully. Your Honour, it cannot be held that taking of the signs in this matter can uphold any degree of public endangerment, meaning that the balance of factors will fall in excluding the evidence from the trial to uphold public confidence in the judicial system. Factor 5. The signs could have easily been taken lawfully under application by Constable Stone under Section 150 or Section 161 of the PPR. Your Honour, by allowing the signs to be seen at trial would be condoning Constable Stone's behaviour. This would be setting a precedent for police entering into private residences' homes maliciously on a whim. This irreparably displaces public immunity, an unlawful intrusion by police officers, and establishes an unjust precedent. Applying these factors, the balance of considerations must weigh in favour of excluding all evidence obtained on the 3rd of November. The applicant submits Mr. Tyler, born 10th of November 2008, should be treated as a child witness. Mr. Smith was arrested 8th of November 2024 and pursuant to Section 21 subsection 21AD subsection AAI, Mr. Tyler, born 8th of November 2008, was 15 at the time of arrest and should be treated as a child pursuant to Section 9E of the Queensland Evidence Act. The applicant finally submits that Mr. Parker's oral evidence is inadmissible. Looking to the relevancy test in Goldsmith v. Sandilands, evidence that is relevant must directly or indirectly affect one of the facts in issue. Evidence of Mr. Smith yelling in the park cannot sufficiently establish any of the facts in issue under what the Crown is alleging in Section 148.1, subsection 2. Therefore, it must be ruled irrelevant and therefore inadmissible. These are all of our submissions. Thank you, Your Honour.